Ladies and gentlemen, I'm going to introduce to you, you guys know Nishad, you guys know Ticon. Those of you who don't, this is Nishad Khan. He is a great friend to our company and a great friend personally. And I want to turn it over to him. He knows everything you need to know. Great attorney. If you guys need any commercials, any real estate work at all, contact Nishad first. He can help you or put you in the right direction. But very knowledgeable, and I really appreciate him coming in at 9 o'clock on last minute notice. So thank you, Nishad. I'm going to turn it over to you as host right now.
All right. Good morning, everyone.
Good morning. Good morning.
I hope you guys are doing well. I don't know how Ryan pulled it off, but he got you a real estate attorney for free for the next hour to throw questions at. So, take this as your gift. But it's good to see all of you. Good to see some familiar faces, Adul, Tariq, and everyone else that's out there. My name is Nishad Khan. I work closely with FRI and Ryan and Carissa. I'm the owner of Ticon Title, and I also have a law firm where we specialize in real estate law. Myself and Michelle are board certified in real estate, means this is what we do. And this is what I've been doing for the last 20 years. And I enjoy it. And I like teaching. So here we are. So I guess what Ryan, wanted me to talk about is the differences between the as-is contract and the standard contract. And I'm going to touch on that, but I'm also going to go over some questions that I have received from many FRA agents over the last few months. Some of these are issues that are happening right now. And these are things that I'm sure you guys will come across and deal with as well. And then if you guys have any other questions, that's anything real estate law related or contract or code of ethics or arbitration, then feel free to ask me that as well. Using the chat device, or I believe everyone can unmute themselves too, since we have an intimate crowd today. Okay, let's get started. So what is the fundamental difference between the as-is contract as well as the residential contract? And so as you guys know, what I'm referring to is the FAR-BAR contract, and the FAR-BAR contract is a package that consists of the as-is contract, the standard contract, as well as the comprehensive riders. Now, most of you are probably defaulting and using the as-is contract. And if I ask you, I guarantee your answer is going to be, that's what Ryan told us to use. And that's okay, because it is an easier contract to understand. But I think it's beneficial you guys understand how the other contract worked, which is the original contract, which came way before the as-is, because there's elements of that contract which will help you in the as-is contract. Okay, so what's the fundamental difference between both? The fundamental difference between both is the way that the inspection period works. In the as-is contract, it's very straightforward. You have a 15-day inspection period where the buyer can do as many inspections as they want or as little inspections as they want. And within those 15 days, if they send a notice of termination to the seller, then they get their deposit back. It's that simple. There's no requirement for a release and cancellation. There's no requirement that the seller and buyer have to sign anything. There's no requirement that they have to agree to anything. What the contract states is if the buyer decides in their sole discretion that they are not interested in purchasing the property, then they have to send a notice of termination to the seller and they get their deposit back. Now, many of you and agents in general always find yourself into these strange deposit disputes where the seller won't sign or the buyer won't sign, and then they won't sign the release of cancellation, and then the money gets stuck there, and then you call me, what do I do? And I have to explain to you, well, the only thing that I can do is something called interpleader, where we take the deposit that we're holding and transfer it into the court. And when we do that, then the court holds on to it and says, okay, guys, whoever wants this deposit, come fight for it. And if the buyer wants it, then the buyer is going to have to file a lawsuit in county court if it's under $15,000. If it's the seller that wants it, they have to file a lawsuit. As you all know, filing lawsuits are not fun and they're not cheap. And so a lot of times you end up spending $1,000 for a $1,000 deposit, and it just makes no sense. So what I have seen that has worked and what I do in my own practice is a couple of things. One, the minute I get a fully executed contract, I sit down and I highlight all of the important dates. When is the, and there's only a few dates that you have to keep in mind. Your effective date. When is the effective date, guys? Okay, I know you guys can unmute and speak, and I'm gonna make you guys unmute and speak because I can't keep talking for 45 minutes.
The last person who signs the contract, or the agent.
Okay, Tariq Tawab is half right. Who can get the second half?
The day after.
Sign.
It's not just when the last person signs the contract, but
Oh,
The
they already
day
received
after.
it.
signed and delivered. That delivery part is key, guys, because if I receive an offer for 200 and I counter by 250 and I initial my counter and the buyer initials and accepts the 250, well, does the inspection period start when the buyer signs it? No, the inspection period starts when I know that the buyer has accepted my counter, because it's not fair for any of the timelines to start until I know that my contract has been accepted. So making sure that both parties get delivery is very important, because what it does is it throws off the timelines and everyone starts getting confused. When was the effective date? Well, I got it, the buyer got it on Tuesday. Well, the seller didn't get it until Wednesday. Well, the effective date was the last person signed on Tuesday. And that's not correct. It's sign and delivery. So what you guys need to do is when you get an executed contract, you highlight the dates. You highlight the effective date. What's another important date that you guys see in the contract?
Inspection date,
Inspection period. What's another important date that you see?
closing,
Closing date, correct. What else?
Loan
Appraisal.
approval.
Loan approval, right? So those are your 5 important dates. Oh, I would also add, the 3 days that the deposit has to be delivered, because, a lot of agents are not keeping track of that. And if you don't, then the contract is in default. If there is no deposit, the seller has a right to say, buyer, you're in default. Now, if the seller continues with the transaction and at loan approval period says, oh, I changed my mind, you didn't give me a deposit in time, it doesn't work. The default has to be called after the 3 days has passed and the seller wants to get out of it. But I would also add that. So your important dates are your effective date, the day the contract was signed and delivered, your deposit date, which is either accompanying the offer or it's deposited 3 days within, and you want to keep track of these dates. The next one is your inspection period, which is usually 15 days in the as-is contract, but doesn't have to be. The next one is your loan approval period, which is how many days under the as-is?
30?
30 days, correct. Thank you,
30
Victoria.
days.
30 days, right? 5 days to apply, 30 days to get the loan approved. And remember, and then your last day is your closing date. Now, the inspection period and the loan approval are very similar, because the inspection period says you have 15 days to decide whether or not you want to move forward with the contract. The loan approval period says you have 30 days to get your loan approved. And a lot of agents think, oh, we have a financing contingency, which means if our loan's not approved, we get our deposit back. That is absolutely incorrect. There is no financing contingency. There is a financing contingency that's limited to 30 days. So you have 30 days to decide whether or not your buyer is approved or not. And that's very important, because if you wait too long, then you're going to have to seek an extension. And if the seller doesn't agree to extend, then you've got yourself stuck. So you want to keep these timelines. So the first thing I would do is get the contract, highlight those dates, and then I would enter those dates into some sort of checklist or even an email, right? Something simple. Good morning, all agents. My name is Abdul Mohammed, and I am the listing agent, and I am sending out a critical dates checklist. And what this is these are the dates that I have calculated based upon the time the contract was delivered. We have 15 days for the inspection period, which is January 15th, the closing days in February, et cetera, et cetera. So once you've identified these dates and send them out to everyone, then if people don't agree, they have the right to do what? Object or disagree or tell you, we don't agree with those dates. But if they keep their mouths shut, it's very hard for them to come back and change it later on. So once you've done that and said, okay, now we've established what the inspection period is. It's, let's say, 15 days from now. I've sent out an email telling everyone when the inspection period is. Imagine on day 14 or day 13, when the buyer says, okay, we found that there's issues with the property, there's, the WDO didn't come out or whatever it is, and they send a notice to the seller. Dear seller, please be advised that we are canceling the contract within our 15-day inspection period. Pursuant to the contract, the deposit will be released to us as buyer. And then you go on. It's very difficult for a seller to challenge that in a court of law and in real life. Because if you took the time to highlight the dates, you sent it to everyone, and within those 15 days, you send them a notice, whether either in email or in mail or not WhatsApp, not text message, but in writing, that you're terminating the contract, how can a seller disagree to that, right? They can't. And if they do, and they try to fight it, well, it's a very easy case, and they will end up paying the buyer's attorney's fees and court costs. But what happens is a lot of agents don't do that. And what they do instead is, when the inspection period is, if the buyer doesn't want to buy the property, they print up a release and cancellation and send it out to all parties. And then when the seller doesn't sign, they're like, okay, now what? Well, your 15 days is gone. Yeah, but we told them we want to terminate the contract. You send them a release and cancellation. It's not the same thing, and that's not what the contract says. Well, that was the intention. Well, now you've muddied the water and you've made it gray. And the thing about contracts and real estate, guys, is the more black and white you keep it, the better position you'll be when a problem comes up. And doing stuff that's outside of what the contract says makes it gray. So, when you have these deposit disputes, follow those steps, and I promise you, it's very difficult. And let the seller who's refusing to give the deposit back go to an attorney. What is their attorney going to say? When the contract was signed, the dates that were sent out. They sent you a notice terminating the contract. There's no reason for you to hold the deposit, period. So those steps I have found helpful, and I find very few deposit disputes when you do that. Okay, so going back to the main topic of today, which is the difference between the as-is and the standard contract, okay? So I'll use an example to kind of explain the difference, right? Let's say Ryan Langley wants to buy a house, and he chooses Denise to be his agent. And what kind of contract are you going to use for Ryan Langley as a buyer?
As is.
As is. Why? Because Ryan's done real estate. He knows real estate. He works for a broker. He understands it. He knows what to do in an inspection period. He knows what to look at. He's sophisticated enough. But let's say Mr. and Mrs. Smith are moving down from Vermont and they're buying their first house in Orlando. What kind of contract would you want them to use? All of a sudden, everyone's quiet. Why? Well, because you think is an as-is appropriate for them? Well, it depends on how sophisticated they are. And if they're not sophisticated, then by using an as-is, it is your responsibility to tell them what to do during that inspection period. And if I'm buying a house in Florida, is a 4-point inspection enough? Not for me, it's not. Not for my parents and not for my clients. Because I don't think that you can really inspect a house by just a 4-point inspection. In the standard contract, you are required to do 3 types of inspections. You have to do them. A general inspection, a WDO, and an open permit inspection. Why? Because these things are important and they don't come up on a 4-point inspection. So if Mr. and Ms. Smith are coming in from Vermont buying a new house and you only do a 4-point inspection, what do we do if there's wood destroying organisms in the house? What if there's termites? What if there's mold? A 4-point's not going to cut into the drywall to see if there's mold or mildew within the house. What if there's open permits? Well, isn't that what title does? No, title search does not see if there's open permits. That's something you get from what you call a lien search. And a lien search is not necessary in an as-is contract. It's only offered if you go to a title company that does lien search for all their transactions, or if the buyer specifically asks for it. But even if the buyer specifically asks for a lien search and they find an open permit, the seller doesn't have to do anything about it because it's an as-is contract. Whereas the standard contract says, okay, buyer, this is the way the standard contract says. Seller says, this is my house, I want to sell it, everything's fine. Buyer says, okay, well, if you think everything's fine and we're going to do certain types of inspections, are you willing, seller, to put some money up in case we find some issues at the house? Sure, buyer, I'll put up $1,000 for a general inspection, $1,000 for WDO, and $1,000 if you find open permits. Because I'm confident there's nothing there. All right. Buyer has to do an inspection within 15 days. They have to use a licensed inspector. In an as-is contract, there's no requirement to use a licensed inspector. You can use your cousin Jimmy, who just graduated from high school, to inspect your house. But in a standard contract, you must use licensed people. Buyer does an inspection within 15 days. Buyer comes back and says, okay, seller, you offered $1,000 for the general inspection. I found $800 worth of stuff. Seller has to pay for it. There's no negotiations. There's no, well, let me think about it. There's, okay, tell me what you found, and I will get my own estimates and see if it's 800, 900. But if the seller agrees that these are problems such as faucet doesn't work, toilet doesn't work, pool pump doesn't work, whatever it is, the seller has to fix it. Same thing applies to a WDO. Same thing applies to an open permit. So what you do is you're eliminating a lot of the negotiations that you do in an as-is contract when you have these repair addendums, right? Because what happens these days with an as-is contract? A $10,000 deposit, 10-day closing, I've got the perfect buyer, which, I laugh when I see that, because is that buyer really willing to close without a title search? Of course not. Without an HOA estoppel or condo estoppel? Because by law, they have 10 days. So no, we need that as well. Okay, what about a lien search? No. So you're not really willing to close in 10 days. It sounds right, but that's not the way it works, because all of these things have to be cleared. So, when the standard contract requires these 3 inspections, and if what the buyer discovers in those inspections are below the threshold that the seller has set forth, then the seller has to provide those funds to repair those items, and the contract continues. Whereas in as is, you do the same thing and you go back and forth. So the thing that I would say is most important to take away the standard, if let's say your broker says only use as is, that's fine. But at least you guys should know the 3 types of inspections that you do in a standard contract. Because if any of you came to me and said, Nishad, I'm buying a house, what should I do? I would say, guys, you got to do a WDO, you got to do a permit and lien search, and you have to do a general inspection. And why wouldn't you advise the same to your own buyers or to your own friends? So looking at the contract and understanding how those inspections work, all of you know what a WDO is, right? If what you're doing is you're trying to see if there's anything within the house, right? The trusses, the beams, that is either destroying the wood. And because we live in Florida, we have elements, rain, sunshine, humidity. People who move from Colorado, they live in log cabins. They don't have these issues. And so in Florida, you have to do a WDO because you want to determine if there's any termites, mold, or mildew. These things cost money to repair and remediate. If they're pre-existing, your insurance company doesn't cover them. And it's a health issue. So, someone who doesn't do that, I think, is putting themselves into a situation where they might have, health issues later on. Same thing with the open permit. Open permits are issues that, when someone builds a house or they add an improvement or they do any construction, if the code requires them to pull a permit, they have to pull a permit. And what the permit does is it's the county or the city's way of making sure that the work is done correctly, because they can go out and inspect it. And by correctly, I mean by code. And the purpose of the code is to make sure, everyone is safe. And so if someone has an open permit, what that means is they started the work and they didn't close it out. So it was never inspected. They started the work and the work is half done, and it has to be updated. They started the work and something happened along the way. And so anytime you see an open permit, it raises a red flag, and it's something that you should look into. And again, doesn't come up in a general inspection, does not come up in a title search. This is something that needs to be done separately. And these things are so easy to do. I mean, an open permit, you can call the building department and say, this is the address I'm looking to buy. Is there any permits that I should know about? And they'll email you. So, it takes 5 minutes. But again, you don't have to put yourself in the position where you're doing this. You can delegate this to, or ask the title company to do it, or ask the buyer to do it. But it's something that should definitely be done. So I see that a lot. The other difference between the standard and the residential is, or the as is that the standard, like I said, requires licensed people to do any work. And so a lot of times, I see this. I see a lot of addendums where seller agree, the agents will put together an addendum that says seller agrees to repair, roof tiles, or seller agrees to repair AC. Well, and when you write that in an as-is contract, that means exactly what it says. The seller agrees to repair the AC. But I don't think that's what the party's intent is. What they really mean is the seller will hire a licensed AC technician to come out and repair the AC properly and provide invoices and receipts showing that it's been repaired. And if there's a bigger problem, it's the seller's responsibility. And if the seller doesn't repair it, either pre-closing or post-closing, then the buyer is entitled to some funds. And so that whole portion gets missed. And when you guys are having these post-closing repairs or any type of repairs, you have to remind yourself, okay, licensed person within a certain time period, to buyer's discretion, right? So if you want to see a repair, it should be done by a licensed person within, within 5 days of closing or 3 days closing, or if it's after closing, within 2 weeks, to buyer's satisfaction. And what that means is you don't have disputes where the seller said, well, I did fix it. No, you didn't fix it. You had some guy patch it up. Well, it looks good to me, but it doesn't look good to the buyer and it's not good enough. You avoid all of those issues by being very clear with the terms that you put in your contract. Okay? Yes, Adul. Let me unmute you. Okay, you can unmute now.
Example, COVID.
Sure.
COVID, you have an AC issue, you're not getting the parts, and you're coming to close on Friday, but the parts are not in yet. What do you do in a situation like that? But they promise to fix it.
Right. So if you're the buyer and the seller promised to fix it and the parts aren't in, why is that the buyer's problem? Right? If your seller is the one who promised to fix it by Friday, they need to figure out how to get it fixed. And if they committed to Friday, I mean, that's a default.
Because it's under warranty, but the parts are not in, can they hold some money, which is what we advise?
Sure. Yes. So, this becomes very fact specific, but what it sounds like, you have an air conditioner that's under warranty, that the buyer wants it to be repaired. Seller says, fine, it's under warranty, we'll have it repaired, but the company that needs to repair it needs to wait for the parts, and that can't happen prior to closing, correct?
Correct.
Yeah. So instead of extending closing, you can say, well, seller will need to escrow, $1,000 of their proceeds until the parts are in and the work is complete on the AC. And if the work is not completed within 2 weeks, then the $1,000 will be released to buyer. So you want to make sure you cover that second part where you say, if the work is not complete, or if this does not happen. And those ifs are what really catch people up.
Okay, thanks.
All right.
Question.
Sure, Daryl, go ahead.
Wouldn't it be best just to enter or have the seller issue a credit towards the buyer so the buyer can hire their own contractors so that there's no problems afterwards?
Yeah, great question, Daryl. So that would be the best thing, right? To allow the buyer to, handle it themselves and not have the seller have to deal with it. But, in a warranty situation, you want to make sure the warranty is transferable and the buyer can do that. But also, Daryl, in a credit situation, a lot of times when buyers are getting financing, they're not able to get credits at closing because it throws off all the financing numbers and they have to go back to underwriting. And so what lenders will tell you is, handle it outside of closing, or we can't give a credit at closing. What you can do towards repairs, but what you can do is you can have a seller, instead of making a seller credit to fix the AC, you can have seller crediting towards buyers' closing costs, prepaids, and points for the same amount. And that'll be okay with the lender, but an actual repair is not going to work.
Okay.
All right, good questions. Anything else?
You just said something that I caught that's kind of interesting. You said closing costs, prepaids, and points. If they don't put points in their wording, does that mean they can't contribute sellers credits towards points?
That's
and only
correct.
Prepaids and closing costs?
Yes, if you only put closing costs in there, you can only credit it towards their closing costs. If you don't put prepaids in there, they won't allow it, because prepaids are technically not closing costs. They're things that the buyer's paying for in advance. Points are technically not closing costs. They're charges that the buyer's paying for the loans. So you have to specify those things, otherwise you won't be able to use it.
So if we see the final statement come through and they're, buying their rate down or whatever, and we can flag that and say they can't do that if they didn't put points in the contract.
Yeah, I mean, you can. It really depends on which side you're on. So if it's the seller who's providing the credit and the buyer's trying to use it towards their points. And so here's the other thing: anytime you have a seller giving a credit towards closing cost points or prepaid, you always want to use the word up to, right? Not seller will give a $3,000 credit, because then the buyer is always going to go for the full $3,000. Seller will give up to a $3,000 credit towards those things. Doesn't mean you have to use the full $3,000. And so, when the situation where that would happen is where a buyer is asking you to use the full amount towards, things that the seller did not agree to. And in that situation, if the seller didn't say points or prepaids and the buyer is trying to use those closing costs or points or prepaids, then if you want to save the seller some extra money, yeah, you can say that and say, we're not going to use it for that. It was strictly for closing costs. So, but it's better to address that on the front end than to deal with it, on the back end. Okay. So, all right. So I'm going to answer some questions here, unless you guys have any other questions. So one of the questions, and some of these are a little basic, but for those of you who are newer agents for FRI, they may be helpful. Okay. So in a FAR contract, why are there asterisks in a contract? Anyone have any idea?
Well, they need to be filled in.
Correct. The asterisks on the contract signify that there's an important section of the contract that needs to be completed. And here, I'm gonna try to share my screen here so you guys can see it. So here's your contract. So one good habit is to go through the contract and highlight any areas that are asterisks. And so the way that I look at asterisks, guys, is yes, there's stuff that should be completed, but they're also reminders of important things that you need to either inquire about or put in the contract, right? So parties, obviously, property address. So these things are things that are important, and it's good for you to look at all the asterisks. Other personal property items. I have seen a lot of people miss this, and unfortunately, I've seen even some of your own friends have to pay out a commission out of their own pocket because they missed items that were supposed to transfer with the property, and they didn't include in the contract, even though the seller told them. So that's the purpose of the asterisks, is to make sure you go through these things and at least ask the seller about them, if not addressing them. Okay, let's see. We talked about the effective date. What makes an effective and enforceable contract? Now, I see this a lot, and it's very important, guys. When you are collecting signatures, okay, this is a big one. Let's say you have a as-is contract and it's signed on Monday. The property is a condominium. And so what comes with a as-is contract when you have a condominium? That you must have?
Should be HOA.
HOA rider or condominium rider, right?
Right. Yeah.
So if the contract is signed on Monday and then the agent says, oh, I forgot the condo rider, here it is, and that gets signed on Thursday by all parties, when is the effective date?
Thursday.
Thursday, yes. These riders, they ride along with the contract. They're part of the contract. And so a lot of time you do not have a signed contract unless you get these items signed as well. And I see this so often where agents will get this contract signed, but they forget about the riders, or they get those signed 2-3 weeks later. And what you're doing is you're opening up the door for the buyer to get out of the contract. And I have used these, and I'm telling you guys from practical experience, when people come to me and say, I need to get out of a contract, these are the holes I'm looking for in order to get people out of a contract. And it's unfortunate, but you lose out on commission when these things happen. So these riders ride along with the contract. You must include them. And it's important to go down to line 569 and say, okay, which riders apply, mark them, and do the extra effort and complete the rider. make sure it's completed, not the first page and the only 2 lines, but the whole thing, because that's also an argument. Yes, you gave me the rider, but by law, you're supposed to complete the entire rider and you only filled out page 1. So until you give me the rider, under Florida statute, I have the right to terminate this contract until I get a fully completed condo or HOA rider. And so these are things that are hard to argue against because the law is very clear. So it's important for you guys to get these things completed and filled out when you return them and when you're collecting these signatures on the contract.
Nishad, Marina,
Yes.
I have a question.
Sure.
I had a situation where the buyer sent over the contract, but I noticed that they failed to attach the CDD. So then in turn, I turned around and drew up the addendum and forwarded it back to them. So was that correct in doing that process, or I should have allowed her to fill out, complete the CDD form sent to me?
No, I think, it's, so listen, you guys are all colleagues. I think in that kind of situation, you should do it because it does, good by, putting the contract in jeopardy and not having completed documents. So yes, the listing agent should have done it. But if you turned around and did it and they signed it, then that's fine. But then the effective date will start from the time that CDD was signed. Now the CDD writer, are you talking about the one for the FAR contract? Because the FAR bar contract does not actually have a CDD addendum. I've seen the Florida Realtors one and I've seen one in Jacksonville. But the full FAR bar contract, believe it or not, guys, does not have a CDD addendum. So if these are the only addendums that they have on the FAR bar contract. And so a CDD, for those of you guys who don't know, is a community development district. It's essentially an HOA with government powers. Anytime communities like Baldwin Park or, they have common elements that are limited to that community, then they have this other governing body that collects assessments from everyone to pay for those common elements. And if there is a CDD, then sometimes like properties in Baldwin Park, for those of you who have sold them, that they'll be subject to sometimes a condo association and then a master association and then a CDD and then property taxes. So there's multiple layers, and it's important to make sure that both parties understand how much is owed on multiple layers, because some of these assessments and taxes are taxed differently. For example, property taxes are paid in arrears. You get your 2020 tax bill in November, but assessments, when it comes to CDDs, are not paid in arrears, are either paid in advance sometimes. And if that's the case, then there should be a proration as to what the buyer has paid in advance versus what the seller is getting. So that's also something, to keep in mind when you're using CDDs. But make sure you sign all the contracts and sign all the riders. All right, let's talk about something else. Sellers backing out of contract, right? The property market is hot right now. Values are going up. Everyone is moving to Florida. And we see where sellers are just saying, you know what? I changed my mind. I don't want to sell the property right now. I want to hold on to it, or I want to wait. You can't back out of an as-is contract as a seller. Once you've signed a contract, you have a commitment. The only person that can back out is the buyer, and they can back out during the inspection period or the loan approval period, and that's it. So, a seller that sends a notice to a buyer saying, I'm no longer interested in selling this property, is only asking to get hit with a lawsuit. And the type of lawsuit they would get hit with is called specific performance, which is buyer has the ability to force the seller to sell the property to them, and buyer has the ability to collect all of their legal fees and court costs that were incurred in attempting to get the seller to sell them the property. So it ends up costing the seller a lot more. And it's, again, very black and white. There's no ifs, ands, or buts about it. A seller cannot cancel a contract in an as-is contract. Only the buyer can. Now, if the buyer defaults by not paying the deposit in time, they can cancel. If there's another way that the seller can cancel the contract in an as-is or a standard contract, anyone have a guess?
If the condo or HOA is not signed?
That's a good one, yes, if the riders are not signed, but assuming everything is perfectly signed, what's another way a seller can cancel a contract?
Loan not approved?
The loan not approved, correct, Marina? So after the 30-day period, if the buyer hasn't already told the seller, hey, my loan's been approved and I'm ready to go, and let's say the buyer doesn't say anything, then there's a 3-day window after the 30-day period where the seller can take the deposit, give it back to the buyer, and say, hey, buyer, I haven't heard from you within the 30 days whether the loan was approved or not. Therefore, I'm canceling the contract and here's your deposit. And then the seller can move on and to sell it to anyone else and go from there. And again, having some sort of checklist where it's very clear, or a critical days checklist of where it's very clear as to when that loan approval period ends, makes that process much easier when you have to cancel a contract and send them back their deposit, because it's hard to question it when you've already set out the dates from the beginning.
Nishad,
Yes.
situation now where rentals and stuff, I mean, I had this before, where the seller can't find a place to live.
Okay.
Can they cancel a contract?
No.
Okay.
If they
What happened was, it happened to another agent and a loan, and I had a rental property for rent, and they wanted, and that's how I found out, and they canceled the contract because they couldn't find a place to live.
I mean, they don't have a right to do it. So if they can't find a place to live, they probably shouldn't have signed a contract, or they should have thought about that, you know, weeks before closing, not the day before closing. But yeah,
No,
if you're
enough time, they had enough. Well, yeah.
Yeah, I mean, that's just, you know, that's poor planning, but you can't cancel a contract for that. I mean, these are contracts, right? These are commitments, these are obligations. You don't go into these things unless you're very confident and certain and you know what the results are going to be. And so when people sign contracts for fun, you know, or don't take them seriously, this is what happens, but you can't cancel them. Now, there's another way a buyer can cancel a contract, and that's if the property is subject to a lease. If there's a lease in the property and the intention is that the tenants will stay in the property, then the lease has to be provided to the buyer within 5 days, and the buyer has 5 days to review it. If that lease is given to the buyer 5 days before closing, then the buyer has 5 days to cancel the contract. And so making sure that, you know, if your properties have tenants in them and you're selling them with tenants in them, and if there is a lease, that's great. If there's not, you have to put it in writing and tell the buyer, these are the terms of the tenant that are staying in the property. It's a month-to-month lease. They have, you know, a $1,200 security deposit, all of those items. And until you provide that, the buyer has a right to cancel the contract.
Thank you.
Yes, Ryan.
Very specific question. A seller backs out of a contract, tries to back out of a contract, just a couple of days into it, the inspection hasn't even been done yet. Let's say they go to specific performance and they are forced to sell the property. You're starting all over again now with the inspection period, because you can't make the buyer close that day. They haven't had an inspection or anything. So you start the contract, you start all the periods over now.
Yeah, you would, so what you would do in a specific performance is, okay, in your situation, buyer signs a contract, seller signs a contract. Within 2 days of signing the contract, seller wants to back out. The buyer would then file a lawsuit and put a lis pendens on the property. And this is one of the few instances where you're allowed to lien a property. And so they would put a lis pendens, which of course would prevent the seller from selling it to anyone, and they would force them to enforce the contract. The timeline begins when the seller says, okay, I will stop defaulting, right? So there's a tolling period. So, you know, the buyer doesn't get penalized for the days where the seller refused to cooperate. So if the inspection period started and 2 days into it, the seller says, I'm not selling it to you, that period stops and the buyer goes to the lawsuit. And until the seller says, okay, I will start selling it to you, there's a tolling where all those days that were missed will start going from there. And that's usually how it works. But, you know, technically that's how it works. But usually there's going to be some sort of agreement between the parties that says, well, we still need time to inspect it.
Sure. Thank you.
Yeah. Okay, well, any other questions? Let's see what I have. Okay, this question I get a lot, right? So, you know, do you need an appraisal contingency if the buyer is getting a loan?
Well, it's in the contract, but I do it as a redundant.
Yeah, it's not, it is in a contract, but it's a contingency that's tied to loan approval, right? So the way it works, guys, is if your buyer is getting an FHA, VA loan, a conventional loan, chances are the bank's going to appraise that property, right? And if they appraise it, the loan conditions with the buyer are that the property has to appraise at the purchase price, or at least more than the purchase price. And so if the appraisal is done within the 30-day period, then that's great, because then you know that you've fulfilled all of the conditions and you have loan approval. But the contract has language in it that says, even though you got your loan approved, if the property does not appraise, then the buyer still has the ability to get their deposit back. Now, when buyers are saying, well, we want to make sure we have an appraisal contingency, that appraisal is not built into the contract. It's just understood that if they're getting a loan, the lender will appraise. And if the property does not appraise, then there's a little small exception that allows them, the buyer to get out of the contract even up to the closing date. I don't like that. I think the appraisal should be done in the loan approval period, because I've seen sellers who, with their 5 children, have packed their bags, have a truck outside, are ready to go. And then the buyer says, we're canceling the contract because the property did not appraise. So, from a seller's perspective, I would prefer that the appraisal happens within the loan approval period. But you don't need both, because a lender is probably going to have that language within the loan, the conditions of the loan, and they're going to do an appraisal already. Now, if your buyer is getting a special type of loan, right? I've seen buyers who get loans from their insurance company, from their pension funds, from their 401ks, and all these different places. They usually don't have appraisal requirements. And so in that situation, you want to make sure you have a contingency, because you want to make sure, as long as the buyer feels that they need a contingency, because the lender is not going to have an automatic contingency. Okay. Yes,
Now,
Brian.
Hey, Nishad, I got 2 questions for you. I know we don't want to be lawyers and write a bunch of stuff in additional notes of contracts, but I got 2 questions for you here. Can we put in there, and it's not really can we, do you recommend that we put in there that when we're representing the seller, that we put in the additional terms, appraisal must be done within the first 24 days?
Yes, I think that's a good idea, because it's good for you guys as agents, because you don't want to work a deal and then find out it doesn't get appraised and then have to cancel everything the day before closing. So I would recommend adding language in the additional comments that the appraisal must be conducted within the loan approval period, which is 30 days.
Okay,
or 45 days.
but we can make up an arbitrary date like 24 days or 20 days.
Sure, yeah. There's no requirement that you have to stick with the 30 days loan approval. You can say it in 5 days.
Okay.
As long as they agree.
Second thing is, in the listing agreement, now that's an agreement between the brokerage and the seller. Can we put language in there that, so they're not, I don't know, I'm sure a lot of my agents are seeing this. Every time you have a listing, you get a handful of lowball offers. Is there a way that we are obligated to present? Can we put in our listing agreement in the additional notes there that we don't have to present offers that are 20% below, or whatever it is, below asking price, or any kind of number like that?
If your seller agrees to it, absolutely.
Okay.
Yeah.
That overrides any legal obligation we have.
Yes, right. So, and this happens a lot, because let's say you go look up a listing and you're about to submit an offer, and the offer says, as is contracts only, or no offer below asking price will not be reviewed, that kind of stuff. So there's a couple of things there. And this is where it's helpful, guys, to know not only your contract, right? When I teach this class, I talk about the 4 C's, and one of those C's, one is contract, one is communication, one of them is code of ethics, because the code of ethics has a recent change that allows you to request some sort of confirmation from the listing agent that they presented the offer to their seller, and they have to do it. And if they don't do it, it's a violation of code of ethics. And so using that as a tool is very helpful, because at least, you know, either they're going to lie and perjure themselves, or they're forced to tell the truth. So when people say, you know, as is contract only, or don't show this amount. So technically, as an agent under 475, as well as the code of ethics, you have to show your seller all offers. But the listing agreement has language in it. And you guys may recall there's a box that says withhold verbal offers. So technically, you're supposed to give all offers to your principal, who's your seller. But if it says withhold verbal offers, then you don't have to give verbal offers. There's also a box that says, you know, you don't have to show them any offers once the property is under contract. If they check that, then you don't have to get it. But if the seller says, listen, agent, I'm not looking at anything other than an as-is contract that's above 350, then those are your charging orders. And if that's what the seller is requiring you to do, then you're entitled to do that as a listing agent. As a buyer's agent, you have no right to say, prove it, right? All you have to do is say, you know, here's my contract. We need confirmation that you submitted to the seller. If they say, well, my seller has specifically provided me in the listing agreement that, you know, I can't show these contracts to them, then they have to put it in writing and send it over to you. But unless there's some, if, you know, there's a lot of agents to say, no, I'm not going to waste my time, or maybe they're working another deal, that's where that confirmation of that they've showed the offer to the seller is very important. All right, Idul, I think you had a question. Go ahead.
Oh, no, I think Ryan was asking a question.
Okay, the other, go ahead.
From my understanding is the appraisal, which I have an appraisal date written on mine, one of the dates, because right after inspection, you know, you have to have the approval to do the appraisal, which, you know, will take another week or so. So I put that into my contract to know after inspection days, 10 days, another 15 days, they should have appraisal done before they go in underwriting.
Yeah.
Kind of push them into that. So I keep that date kind of like handy.
Yeah, you know, and I've seen that before where agents go 10, 10, 10. So 10 days to get the inspection, 10 days, you know, they get the appraisal done, and then 10 more days to get the loan approved. And then that's within the 30 days.
Right. Okay.
Nishad,
Yes, Marina.
going back to the confirmation from the seller, what would be a valid confirmation to receive from the?
So there's the form, there's actually a form that the National Association of Realtors has provided, but they just have to provide you a confirmation in writing. So an email saying, yes, the offer has been presented to my seller is appropriate. You know, a text message I think will be fine. But really it's to push those agents that are ignoring or not even responding, which is very frustrating, of course, right? When you're trying to get a hold of them, they don't even respond, to force them to at least communicate with the selling agent.
Perfect, thank you.
Yes.
And
Okay, yes.
Ryan reminded me of a question I have. This is kind of petty, but it drives me insane. On the MLS, some agents will do like 2.5% minus 350, whatever their transaction fee is. I'm curious, does that need to be stated in the listing agreement whenever you go down to the section past compensation where you're cooperating with brokers? Should it say in there 2.5% minus that, and they have to get the seller's approval in order to put that on the MLS? And if they are offering that on the MLS and we get to closing, can I ask title to confirm that in the listing agreement that it says that? I mean, I know it's really petty, but I hate.
No, it's actually not petty.
Bucks.
Yeah, it's not petty, Dalton. It's actually a big issue. So, and this question was also presented to the Committee on Code of Ethics. And so what they said is, you know, there's no requirement that because the 350 is not the compensation that the seller is providing, it's the charge that the broker is charging the selling broker. So it's separate and apart from the commission, therefore it's allowed. So, you know, the way that it works is the seller says, okay, I'm going to pay Abby X amount. Abby goes on MLS and says, hello, everybody, I have this property. Seller is paying me X amount, but if you get me a buyer, I will share from that X amount and I'll give you 50% of it. But Abby also has a right that says, in addition to 50% of the X amount, my broker is also going to charge you $350 if you bring a buyer for this property because it is our listing. So that's not a commission, that's a fee that the broker is charging on MLS. And they can do that because, you know, you may have seen properties that are really hot and those brokers can pretty much dictate, you know, what they charge in order to get those properties, but they're not changing the commission. They're just adding their fee, and that's perfectly fine.
But the commission that they're paying on the MLS, the 2.5%, 3%, 4%, whatever it is, that has to be agreed upon with the seller in the listing agreement, correct?
Yes, right. So,
But the fee, you're saying the fee is separate from the commission. It doesn't need to be confirmed by the seller. They can do that if they want.
correct. Yes.
Okay.
Yeah, what they're sharing, and you know, technically, what they're sharing with other agents, the seller does not have to agree upon, but it is in the listing agreement to keep things clear. There was a recent class action lawsuit against the Association of Realtors, which kind of talked about that. So it says that, you know, this is how much we're going to share. But if you ever look at the listing agreement, it says that, you know, seller pays me 6%, we share 3% with a selling agent that is a transactional broker, 3% with a selling agent that's a single agent broker, and 0% for an agent who's a non-representative broker. And the question is, do any of you guys check to see whether the selling agent is a transactional single or non-rep? Because there's a chance that you're paying non-reps commission when they're not entitled to it because the listing agreement says you're not allowed to. And so that happens a lot too. And how do you check? You ask them, right? And these are like the little holes in the real estate industry that haven't been filled, because if they say yes or no and they lie about it, there's not much you can do. But you know, those listing agreements also say that. There's one thing, Dalton, that you can't do, and this is a big issue. Once you offer a compensation in MLS, you can never change that commission or that compensation again throughout the transaction. You can't say as part of the negotiating back and forth that, you know, well, seller accepts your offer as long as the selling agent takes less commission. That is a huge no-no. That is a code of ethics violation, because if a listing agent offered an amount and you brought a buyer, they cannot change an amount. They're committed to, they have a contract between the listing agent and the selling agent. They're committed to pay that amount. So anytime you guys see that, you know, anytime you see these type of violations, you don't call them out at the time. You say, okay, you know, do what you need to do. And after it's said and done, then you file the complaint. And then, you know, if there's a violation, then anyone could be fined up to $15,000, and they may have to pay you back your commission. So that's in. So Dalton was talking about procuring cause issues. You know, that doesn't go to FREC. Procuring cause issues go to ORA. There are arbitration issues, and there's an arbitration process in all of the realtor boards whenever you have a procuring cause issue. And remember, as Ryan mentioned, he's been involved in those. The people who are making these decisions are agents. They're people who are on the streets, who are working out there. And what they're really looking at is, you know, who's really entitled to that commission based upon the facts. Who did the work? Who was really there with the buyer? Who put the deal together? Not, hey, you know, I showed the buyer the property, I'm entitled to the commission. So they are your colleagues. And so having those facts and having those patterns and keeping those kind of records are very important when you go in front of them.
Right. What if you agree to change the commission?
That's perfectly fine. If broker and broker agree, sales agent and sales agent cannot agree. Only the broker and broker can agree to change the commission.
I have a question.
Yes.
What if after when you have a first buyer, the commission rate was different, but then after that buyer backed out, and then you put the house back on the market, can that commission be changed before another buyer picks up on that house?
Well, they have to take down the listing and
Right.
relist it with the new offer and compensation. Yes, they can do that because they took it down and they put it back up.
Okay.
All right. Let's see. Tariq Tawab, I see your hand is raised.
Hey, Nishad, how are you?
I'm good.
Hey, I had a question. This is regarding multiple offers. It's like, as a buyer, let's say the seller, you know, we go back and forth and there's like, you know, 3 offers, let's say. And as a buyer, do I have the right to ask them, hey, can you show me the other higher amount, which you know, someone's giving more than mine? I mean, is that allowed for the?
No, they're under no obligation to show you or give you a copy of the amount or even tell you what the other amounts are that they've received. They can tell you if it's, you know, greater, more, close to asking, whatever, but they have no right, they have no obligation to tell you this. You can ask anything, but there's no requirement.
Right, but couldn't it be bluffing also? I mean, like a bluff game, like, hey, there's an offer of $1,000 more than what you're offering. Can you go up
Yes.
$1,000 more?
Ryan, you had something to say on that.
I think he's asking like an escalator clause. Well, I thought he was asking like an escalator clause situation, which they have to show why they kept increasing your offer afterwards. But they shouldn't be telling you, and Nishad, I'd love your opinion on this. They should not be telling you I have an offer $1,000 more than yours under
Yes.
any circumstance.
That's correct. They should not be saying that. Because you can ask them, what's the offer, what is it, but they have no obligation to tell you. And if they're bluffing, I mean, that's part of sales, right? They can bluff and they can say we have someone interested, and you can't. They're not breaking any laws if they're lying or fibbing or whatever the case may be. Yes, Ryan.
Again, for the people in the back, it is legal to bluff you and stuff, because I get people, I think they're bluffing. They didn't have any offers for 3 months and now they have multiple offers. They're lying, blah, blah, blah. That is sales. They can't
That's
do that.
part of the game, right? This isn't, they're getting the best price for their seller, and maybe their sellers will telling them, go back and tell them we have other people that are interested. They can do that. And you have to do your job to see if you could get your offer accepted. So there's nothing wrong with that. But you can ask Tarek, they don't have to disclose.
Question, if the seller gives permission to tell them what the current offer is, can they release it then?
Sure, yeah.
Sellers gave permission.
Yeah, I mean, that can happen. Hey, Daryl, my seller has an offer for $988. If you guys are willing to go higher, then they may look at it, but the terms have to be better. So, right. They can't tell you who the offer's from and who the parties are, and that's, bad practice, but they can certainly tell you what the number is if the seller allows them. And I think that's, you guys have to understand the seller is looking to you guys to help them with how to handle these situations. And so it's your job as an agent to advise them, in order to get you the best price, this is what I suggest we do. Why don't we go back to the buyer and say, this is the number, or come in. If the seller says, sure, I agree, it's perfectly fine, but they're really looking to you to give them that advice. All right, okay, well, that's my cue.
Thanks, Nishad.
You're very, very welcome. If you guys have any other questions, you know how to get a hold of me. Otherwise, I will turn it over to Ryan.
You guys do know how to get a hold of them. It's 407-228-9711. Nishad Khan and Ticon does a great job. Nishad oversees that, and they are busy and doing great. So be sure to use them, and you guys actually save $100 on your transaction fee, as you know, on your client's transaction fee. But the best part about them is I can get a hold of Nishad. You can get a hold of the people who work there, which, the only way they can beat each other, title companies, is on service. And Nishad's company does a great job with that. And they'll get back to you and they'll tell you what's going on. And so thank you very much, Nishad. Nishad, will you make me the host again?
Sure.
I appreciate that. And you can't share the screen if you're not the host. So that's why we did that. Did you do it?
You are the host.
Awesome. Oh, good. I can mute you. Okay. Well, thank you, everybody. Thank you, Nishad. Everybody, thank you very much. I'll stay on here for about 5 more minutes. If anybody has any questions that you don't want to bother Nishad with about our company. So I'll stay on for a little bit, but thank you very much, Nishad, and appreciate you coming in.
Thank you, Ryan, and everyone have a happy new year.
You too, buddy.
You too.
Happy holidays.
Brian,
All right, you guys, yes, ma'am.
would you please repeat Nishad's phone number?
407. Oh, actually, I'll put it in the thing too, but 407-228-9711.
Thank you.
Putting it in there right now.
So, Ryan, I have a question.
Yes, ma'am.
Is it because a lot of these MLS listings, they say use as is contract. So is it better to use the as is or the standard?
That's what Nishad argued and I argued about on the phone yesterday. Not
because
argued about it.
Yeah.
Okay. He made it very clear, I don't know if you caught the first part of that, Sunana, of his presentation, but he made it very clear that if you know what you're doing, the as is gives you the flexibility to do bits and pieces of what needs to be done without having to do everything. He didn't really get into details, but he does it, guys. He does a 3-hour class on this, so he didn't really get into too much details. But in the standard contract, what some people call the crisp or whatever, if I get an inspection and you don't like my inspection that says that you have to spend up to 1.5% of the value of the house on my repairs, you don't like it, then you can't just argue with my inspection. You have to hire your own inspector as the seller. And if those two inspectors don't agree, then together, and we can't agree on what they came up with, then together we have to split the bill on a third-party inspector who neither of us picked. Okay, it's very binding. It's very bound up. I prefer that you know what the heck you're doing and you get your client to do the things that they need to do for them specifically. So when I say that I prefer the as is, it's because it gives you the flexibility to do the things you want to do. If you sign, how many of you guys have had buyers who buy and then 3 days later they have buyer's remorse? Very common to have buyer's remorse. So you guys ever had buyers with buyer's remorse and they want to back out, even if just because the tiniest thing in the inspection, and you know they wanted to back out anyway? If you have a standard contract, they cannot back out. If the inspection comes back right, they can't back out, the buyers. They have to they have to fail their financing contingency somehow. It's really inflexible for both the seller and the buyer. Then you start arguing over, guys, I see all kinds of this stuff. So then you start arguing over what is a general defect and what is a cosmetic defect. And is a crack in the pool a cosmetic or general defect? If the pool's cracked, what is that? Does anybody know? Is that a real defect that the seller has to cure, or is that a cosmetic defect? Who knows?
It's a general.
It is, Carol. But what if the deck where the pavers are next to the pool is cracked and there's a thing like 2 inches in it?
That's cosmetic.
That's cosmetic, right? A tiny little crack in the pool is general, but a crack in the patio around the pool is cosmetic that someone could put their foot into and bang their head on the side of the pool. I mean, I don't know, but so there's there's all kinds of little things like that all over the place that have to be argued about when you have that kind of thing. So it's very binding. I want you guys to know what needs to be done for each buyer in each situation, obviously, right? Do you guys know how the prices are, how it affects the buyer? Hiring, they have to hire a general inspector, a WDO inspector, wind inspector. They have to hire all these things, or a permit inspector for every deal. And what if there's something very basic that makes them walk away from the house that they find in the general inspection? But they still have to hire all these other inspectors as well. So it's very inflexible. So I like as is. I prefer as is. Sunina, it is completely legal for them to request an as is in the realtor remarks. It's perfectly legal for them to say that. Like Nishad just said, if the seller only wants to see as is contracts. How many of you guys have worked with people and they think the as is means that you get the house exactly as it is right now? There's no negotiating. That happens a lot, right? A lot of sellers think, oh, I just want it on an as is because I don't want to fix anything.
I'm not fixing anything.
Right, I'm not fixing anything, so make sure it's an as is, because they thought they've heard that somewhere before. They think as is means as it sits right now with, dirty toilets and everything the way it is, right? That you're just going to come take my house, take over. And then we know that's not the way it works. So use your discretion, but I prefer the as is because most of the problems that we can't get out of are contract related to the standard. If that makes any sense for you guys.
Well, it makes sense if the seller, states as is contract, and they're not going to fix anything. If we do a standard contract and we put, you have to fix up to a certain amount, they're not going to do it anyway, right? Because
they're not. And one thing I do if I'm on the seller side, I go through and zero out those 1.5%.
Right.
Because I don't want to be, I don't mind negotiating to fix things, but I don't want to be bound up to 1.5%. You sell a $400,000 house and that's $6,000 for each one of those boxes that they could get.
Right. They don't want
that's
that.
1.5 plus 1.5 plus 1.5. And they're different things. They're not all going to come into play, but that's what you're bound to.
Money. Yeah.
And frankly, even if I'm on the buyer side, if I've got WDO, what good is $6 grand going to do me on a $400,000 house, right? If I've got termites or something, right?
Yeah.
So it really, that's kind of a, I don't like it at all for either party, but that's just me.
Ryan,
Yes, ma'am.
if you have a client that does say that they want to sell their house just the way it is, they're not fixing anything up, is there something that you should write or should do?
You don't have to use an as is. Require, tell them they want to use an as is. You don't have to. Daryl brings you a client, and Daryl's client doesn't like this, doesn't like that. This is broken, that's broken. Daryl's client can walk away. You don't have to fix anything. And an as is, that gives the seller the flexibility not to fix anything. It also gives Daryl the opportunity to ask for the world if he wants, right? So it's nothing is done in an as is. That's why nothing's done in an as is until the end of that inspection period, when we come up with what we're going to actually do. You know, right now you're not getting as many requests as you do during a buyer's market. When it's a buyer's market, they want everything fixed. Right now they know not to mess with you because it's only been 6 days and you're just going to put it back on the market. So right now, and this is what I tell you guys, you can be a little bit of a bully when you're on the seller side right now, because what you tell them, Daryl tells me, we want this fixed and that fixed and this fixed and that fixed. And I said, well, send me an addendum with that, and then send me a cancellation. I'll see which one they sign. And then Daryl's going to say, go back to his client and say, listen, I don't want to get too greedy.
For Ocean Pine Circle.
I don't want to get too greedy here. So let's see what we really want. And one thing that Nishad touched on as well, which I greatly prefer, guys, it gets very sticky, as Idul knows right now, it gets very sticky with these repairs. If you can get an estimate and say, how about instead of fixing this, you give us $918, which is our estimate for it, just a concession for that, let's do that. Because because when I need something repaired by a licensed person or not, to the standard of someone else, a third party, a buyer, when you start doing that, it's up to the buyer's sole discretion if I fix my air conditioner properly, or if I fix this hole in the wall properly. You don't want to get into that. Just if you can help it. All right, I've got a hole in my drywall. That's a $250 problem. Let's give you a concession for $250 and you get it fixed.
That way.
Go ahead.
Did you ever get a call from the agent? The same question I asked. Seller backing out.
I've got different. I've had 3 of those in the last week of sellers backing out at various points in the process.
Yeah. Okay.
One just changed. Well, one didn't get the house they want, so they tried to back out very early. One just had a change of heart, and then one saw their they at the last minute they didn't get the move that they wanted to. But no, I'm not talking about yours, Idul.
Ryan, I have a question about what Nishad asked. Well, actually what he mentioned about sellers can back out after the loan approval period.
Yes.
They have 3 days if they're not notified. Am I hearing that correct, or?
Yeah, absolutely. It's in the contract. It's in it's between 86 and 116 or something like that. But that's what I go over with you guys. You guys have been in this training with me when I go over just the loan approval period. Okay. Assuming you don't change the default of 30 days 1 through 30, the buyer can back out. Days 31, 32, and 33, the seller can back out if they have not heard from the buyer.
Okay.
Okay. The buyer does get their deposit back if the seller cancels the contract. It says that specifically in there. So the seller can cancel the contract and give the buyer their money back, but they're out of it at this point. You call that a no faith period or whatever. They haven't heard from you. They don't have any faith that you're going to close. They can back out of the contract. This is why we have to do a great job if we're on the buyer side and keep the seller's agent informed of what's going on.
But the lender can inform us on behalf of the buyers.
The lender can inform on behalf of the buyers. Yeah, but the lender should inform you that the loan's been approved. So during that 30 days, you have 3 things you can tell the listing agent. You can tell them, assuming you're the buyer's agent, you can tell them we have approval and we're going forward. Awesome, right? That's what you hope for. You can tell them we don't have approval, but we're still going forward because we have faith right? We have conditional approval, we have whatever, we really want this house, we can come up with the money, et cetera. Or you can tell them we don't have approval and we're not going forward. So you either have approval or you don't. If you have approval, then you're going forward. If you don't have approval, then you can go, we're still going forward, or we're terminating this contract and we want our money back. See you later.
Okay, thank you.
But yeah, if you don't inform them, this is why I tell you guys, keep a calendar, keep these dates up. If you don't inform them by day 30 in writing that we have approval and we're going forward, we don't have approval and we're going forward, we don't have approval, we're not going forward. We don't tell them one of those three things, you're at risk of them canceling your contract on the 31st, 32nd, or 33rd day. All right. And your client is not going to be happy with you if it's just because they didn't get informed.
And a possibility of claiming their deposit.
No, they get their deposit back according to the rules of the contract if the seller does that. But they're going to be out their appraisal and their inspection on that house, because now they can't buy that house. They're going to have to go find another house. And so they're going to be out there in appraisal and their inspection, and they're going to be irritated with you.
One thing I had an issue with, which I presented a lawsuit against it, a buyer's agent actually had a contract on a penthouse that I listed downtown. It came back that the buyer's agent said that they were not responsible for going through with the contract because they never got the condo documents. And I looked back at the condo writer and she never requested the condo documents, which that was my reprisal, and I won the lawsuit. My
Yep.
sellers, and we relisted the penthouse, resold it, and actually claimed the deposit from the first buyers.
Good. Good. So somebody, they obviously, they weren't interested in those documents the entire time. They weren't bugging you for them the entire time. They just tried to use it as an excuse to get out at the last minute.
Yeah, the buyer's agent had no idea what she was doing, unfortunately. I tried to warn her before the closing day was up. She completely ignored my warnings, and that's where I went to.
But Ryan,
Yes,
that
sir.
usually happens in a loan approval. That usually happens when the seller has another offer, right?
Yeah, typically, yeah, if they're going to cancel with you, it's either because you're not being responsive and they've
Yeah.
lost faith in you, or they have another better offer. How many of you guys have had listings where you take an offer and then you get a better offer later and your seller wishes they could take that other offer? It happens, right?
Correct. Okay.
Well, if they get the opportunity on day 31, 32, 33, they'll do it.
Yeah.
Especially when you're out there floundering around. And that other offer is cash and for the same amount, and it'll close in 3 weeks. You know, so just be careful. Follow your timelines closely. Any other questions or any other comments?
Ryan, hey, I had a quick question about, do you recommend, because of the COVID and everything, with the lenders delays and everything going on, do you recommend like at least 55 days for close?
I do, but you got to be competitive. So that's a tightrope to walk there with closing dates. I do. I think it's at least 45 days now. They can call it COVID if they want. They're just doing a bunch of refinances because they're easy and they make money. And they're saying that they're putting new purchases first. That's what mortgage brokers are saying right now, but it's not necessarily true. I would try to get 50 days if you can. Guys, if you're doing a good job and keeping everybody updated all the time, and the lender's keeping everybody updated, if you go back and you tell them you need 5 more days, they'll do it. Okay? It's the people who aren't keeping people notified. They don't trust you because they haven't heard from you. Those are the ones who or they have to keep bothering you about it. Those are the ones who don't want to extend your contract. Because the seller knows, even if they could have gotten a better offer in the meantime, that you're 5 days from closing, they don't want to start all over a 45-day contract. Does that make sense?
Yes, perfect.
But you do have to be competitive. So I realize that a lot of multiple offers out there. It depends on what your price point, where you're at with the price point. Any other questions or comments? Did you guys enjoy Nishad today?
Yes.
Yeah.
Awesome. Awesome. Appreciate him coming in. All right, guys. Well, if there's no other comments or questions, then we'll have a wonderful day. Appreciate everybody coming in. Love it when you guys are in here learning, especially from experts like Nishad. I really appreciate it.
You have a meeting next week?
Oh, good question.
Coming up.
Not if I can help it, Nishad, or Idul, not if I can help it. No, we may just have an open, I won't have a guest or anything, but we may just have an open forum where you guys just come in and if you have any questions or anything you need to talk about.
Ryan, sorry, is it possible we can do like a land contract for next one?
I think didn't I do a land contract one a couple weeks ago?
That was a while back.
I think I did one like 6 weeks ago. It's definitely on, Abby, there's a land contract one on YouTube, right?
I didn't find one. I was trying to look for one on there. I didn't see it unless I overlooked it, but
it may not have been labeled that. It should have been. But if not, I will do it. And you know what? I will meet you here next Wednesday and we'll talk about it if you'd like.
Cool. Same time, 9 o'clock?
No, it'll be 10:30. Unless I change it. I did this one 9 o'clock for Nishad.
Hey, Ryan.
Yes.
Want to give you an update. I closed the deal in Fort Lauderdale and now I'm going to be doing a deal in Miami.
Oh, fantastic.
So yeah, I just want to let you know that I got experience down there. There are a bunch of wolves down there, but I did it.
Yeah, and it's got a lot of the rules are different and stuff. Their paperwork's different. There's a lot of different stuff down there.
Yeah, great experience though. So I'll let you know now in the Miami territory.
Well, congratulations.
Thank you.
New experiences and new money. That's good.
After 9 offers, just to let you know, took 9 offers to close that deal.
Wow. Not surprising. Everybody and their brother is moving here.
Yeah. Good things.
Yes, ma'am. Well, fantastic. Anything else? I will see you guys next week. I'll come on. I promise I'll come on. I might not have a great agenda or anything, but I will come on and answer questions and talk about whatever you guys want to talk about.
All right. Thank you. Have a nice weekend.
Thank you.
All right. You guys too. Take care, guys.
Bye.